All righty. Hi again. So our next panel's going to address the increasingly common situation in which merger litigation is commenced, often simultaneously in multiple state and or federal courts. Typically, the cases challenging a transaction filed in separate courts include relatively similar factual allegations and assert the same or similar types of claims. Now, the plaintiffs bringing these suits don't want to give up their chosen forums. The defendants don't want to litigate the same case twice in multiple jurisdictions and generally seek the comfort that the court before whom they're litigating has experience in matters of this type and familiarity with the governing law. Now, and nearly everyone usually agrees that it doesn't make sense to litigate the same case twice. But there's often significant disagreement about which court should hear the matter, and even significant disagreement about how the courts should go about making the decision of which court should hear the matter. So, needless to say, this remains a hot topic in merger litigation, and we have a terrific group here to discuss it with you today. Immediately to my right, Professor Robert Daines is the Pritzker Professor of Law and Business at Stanford. He's also the co-director of the Rock Center on Corporate Governance, where he focuses on the interaction between law and business. Before entering academia, Professor Daines was an investment banker at Goldman Sachs, as well as a lawyer. And he is the co-author, along with Olga Kumrian of Cornerstone Research, of a publication called Shareholder Litigation Involving Mergers and Acquisitions, which is, at least in the last several years, been an annual publication. Next to my right, Juan Monteverde is a partner at Faruqi in New York, where he chairs the firm's shareholder merger and transactional litigation department. Juan has been litigating merger cases for many years and has appeared repeatedly in courts all over the country on these matters, and he brings a valuable perspective on multi-jurisdictional litigation from the plaintiff's side of the aisle. Next to his right, Ken Nachbar is a partner at Morris Nichols in Delaware, where he's been specializing in M&A litigation and related matters, practicing in this area for the past several decades, and like Juan, has a great deal of experience with multi-district litigation situations. And finally, on the far right, Neal Potischman is a partner at Davis Polk here in Menlo Park, California. Neal heads up Davis Polk's West Coast securities litigation practice and also has extensive merger litigation experience, particularly in matters with the California nexus. So, like Juan and Ken, he has extensive experience with multi-forum matters. Now, before I get into peppering the panel with questions, I'm going to ask Professor Daines to present a PowerPoint that he's prepared that relates to issues relating to the frequency of merger filings, where the cases are being filed, how they're being settled, and matters of that sort. So, Rob, I'll leave it to you.
Thanks for the invitation. I've been asked to give a brief overview of M&A litigation and some of the recent trends, and I'll say I can give you a few stats and a few numbers, and then turn the time over to the experts to talk about how this actually plays out in different forums. What I'll be primarily doing is giving you the results of a study that Olga Kumrian, who's here, and I did. She did the work, and I'll talk about it. So I'll be presenting mostly her fine work, but she'll get the credit. If there's anything right, she probably did it, and I'll probably mess it up if there's blame. So I thought I'd give you just a brief overview of where we are, and you can see sort of the underlying trend or the dynamic that's going to give rise to the sorts of considerations that we'll talk about after this. You see now the general trend in M&A litigation. You can see this is from Cornerstones and our research recently from 2007 to 2012. Obviously, there's a big increase in M&A litigation. That shows up in the total number of suits that have filed, which have roughly doubled in the past 5-6 years, as have the total number of cases per deal. So there's a lot of litigation. There's a lot of lawsuits per deal. The thing that a lot of times reporters call and ask me, they ask about this middle row, and they say, well, litigation's down recently. And if you look at that middle row, the total number of deals that are litigated are down a little bit. And so sometimes reporters will say, oh, well, things are tapering off. The difference is, of course, that's just a function of total deal volume. If you look at the fraction of deals litigated, you can see that for the past few years, essentially every single deal gets litigated, essentially every single big one. We have the numbers here at 96%. You know, if I had to predict, I bet you they were all litigated and we just couldn't find the one or two that are out there. Or maybe I should sell them to Juan or something. I can find those out and tell you which ones don't have anybody, and we can work something out. But this is a significant increase recently, and compared to 2007, it was about half the deals, and if you go back about 10 years, looks like about 20% of the deals were litigated in large samples. So it's a significant increase in the past few years. There's a little bit of variation between the sizes of the deals. That is, big deals are a little more likely to get litigated. If you look at the ones over $1 billion, it's 96%. And 100 million to 500 million, only 86%. The defense bar here will think that only in front of the 86% doesn't belong. But still, there's fewer suits per deal, and obviously fewer of the total deals are litigated for the relatively smaller deals. Here's a list of the winners. The total number of lawsuits. Obviously, if you get this much litigation, there are going to be a few firms that generate a lot of lawsuits. And you'll see on the far right, some of these produced significant outcomes for their shareholders, and then there are others that, in spite of the large number of cases, here the lowest is 17, produced disclosures, which may or may not have been of benefit. So that's the trend. A lot of it, a lot per deal, and it happens relatively quickly after. On average, the last year, I think the cases were filed about 12 to 13 days after the deal was announced. Now, one big trend that we're here to talk about is jurisdictions. Where are these cases litigated? The general background for this for the past few years has been some concern or celebration, depending on your point of view, that the deals were leaving Delaware, that the litigation was leaving Delaware, and there was papers and some studies written earlier that show this blue bar on the bottom, that over time the cases that just show up in Delaware have been decreasing over time, and people talked about the flight from Delaware, and a lot of it to California. If you take a look at just where in our sample, which is all the deals we could find, there is reason to think there's obviously a lot of litigation, going on elsewhere. 900 lawsuits in Delaware, but other states are significant. Santa Clara County, it's interesting to note. Randy, I'm not calling on you right now. See, it didn't even matter if I called.
Do you limit it to Delaware courts, or is this all courts?
This is everything. That we'll have separately, we'll show just Delaware courts. In Santa Clara County here, we have 120, so it'd be in the top 5 states. If Santa Clara County were itself a state, it would generate a lot of the litigation. We find that the flight from Delaware is overblown. If you look at just the past few years, the percentage of cases that are just in Delaware, that's that top light blue line, has increased, and the number of deals that are only in other states have decreased. So there are more deals litigated in Delaware or in Delaware in some other form, as we've talked about. Still, this is the 65% of the cases of the total deals are litigated in Delaware and another forum. So that's the kind of multi-forum jurisdiction that we're here to talk about. It's a lot of them. I'm going to skip this just to say that I guess that there are a lot of cases that Delaware and another state, and Delaware state and federal. So often you see at least 3 different jurisdictions. What are the outcomes? Just to give you a little background, as of 10 years ago, a third of all cases got additional consideration, and the consideration when it came was $15 million. In this study that I'm talking about in Indiana Law Journal, or another study showed $50 million. So a third of the time there was additional consideration, and the consideration was potentially significant. Here's the recent settlements announced that we were able to locate. Again, it's not all of settlements. Not all of them are made public, but for the ones we could get access to, 81% of all settlements included only disclosures where the proxy would be amended to say a little more about the investment banker's process, maybe something about management's incentives, but no additional cash consideration or changes to the merger agreement. This row here is a concern to many people who think that potentially the disclosure-only settlements generate a lot of litigation but may not produce anything for the shareholders, and that's a matter that people are going to talk about, especially as you see the monetary benefit to shareholders sort of decreasing over time and the settlements that produce just disclosures look pretty high. That's not to say this, money's never produced. Here's the list of the largest settlements, and people in this room know a lot more about these particular settlements than I, and have reason to be happier about the settlements than I do. So I'm going to just say that obviously sometimes there's big settlements. Most of these involve conflicts of interest, usually with the investment banker or potentially management if they're the buyer. Last thing, again, I find myself in the weird position of talking about something I know less about than other people on the panel, but I have maybe a little more data that I'm willing to share, which is attorney's fees. And here I have data on plaintiffs' attorney's fees. Obviously, defendant lawyers don't work for free either. It's just that their fees are a little harder to come by. So sometimes counsel is.
I'm going to stay quiet, okay?
Okay. All right.
So you can finish.
Okay. Sometimes defense counsel is interested in this. We have some data on this that on average in Delaware it's a little over $2 million, and in other courts it's about $1 million. And other courts look like they're more likely to grant everything the plaintiffs ask for. Of the sample we found, all but 3 outside of Delaware, all but 3 plaintiffs' settlements were granted in full. So now this is just the ones we could find. Obviously, that's an incomplete sample of all settlements. Obviously, I'd be happy to get better data from people here who have better data on plaintiffs' attorneys' fees. I'd love to get that. We have a little bit of variation. Again, other people in this room may know more about this, especially with some people here on the slide. But here are the number of awards and the average percentage of requests. There's some interesting trends, potentially. I won't say much here, but Travis Laster grants on average is less generous when measured against the total requests granted. That's not going to surprise some of you, but his average award is, when he gives one, is pretty big. It's a second compared to only Vice Chancellor Strine. I'll skip this. If you take a look at total plaintiff's fees, if sometimes defense counsel is interested in predicting how much they're going to need to pay, and we took a look at this and estimated what determines total fee awards. The biggest determinant is the deal value. Obviously, bigger deals produce bigger settlements on average, but producing settlement fund, for every dollar produced to the settlement fund, there's attorney's fees go up on average by 21 cents, and the number of cases is also significant. The more cases that are filed, you get about $100,000 added on to the plaintiff's fee, at least in our sample. Last, I'll conclude just with the data on the disclosure-only settlements. This is the one that's generated the most comment. Are these useful or not, and how significant is the cost? Obviously, if we're getting some general deterrence benefit from plaintiffs' attorneys paying attention to these, this is where you might look for it. And here it's about $500,000 in our settlement, even in cases where there's only disclosures provided to the settlement. So it looks like it might be a meaningful cost. And I will shut up. Thank you.
Yeah. Thank you, Rob. All right, Juan, it's your turn. Let's start from the plaintiff's perspective on where to file cases. And by the way, feel free if you want to start, if you have anything you want to say in response.
Yeah, I think I want to respond to Professor Daines.
Why don't you start with that, because you seem kind of anxious to do that.
No, because
so
I think, and thank you, I think there's a problem here, and the problem is very simple. We see lawsuits, right, they're increasing, but what we see from the plaintiff bar is the same mistakes keep getting made. For example, you say, why is there so many disclosure-only settlements? Why every proxy omits the same information time and again? So if you want the plaintiff bar to keep coming back, I don't think we're going anywhere, so we're going to do that. But you can't complain when those proxies have issues repeatedly, when the courts have said they shouldn't have it, or there have been plenty of settlements showing what a good form should be. So I think that's a reality. There's also a reality of competition. There's a lot more law firms. And I think that is part of what's driving those numbers up. But I don't think, I don't know how you get to 96%, because I know, for example, of the deals announced in January, I think there were like 6 or so deals, and I don't know what the total number. I think there were 15 deals announced in January, for example. I think 6 went on suit. There was no action. So I don't know How 96%? I'm not doubting it, by the
Right,
way.
right.
I'm not doubting it. I'm saying I think maybe there's some transactions that fall through the cracks. But again, the big issue is why make the same mistake? And if you want to continue making that mistake, then don't complain,
Right.
because we're going to do what we think is right. And what's right is to make sure the information is disclosed.